Intoxication is not a defense to a crime as such, but where a person is intoxicated through drink or drugs and commits a crime, the level of intoxication may be such as to prevent the defendant forming the necessary mens rea of the crime. Public policy plays a strong factor in ascertaining whether the defendant's intoxication may be used by a defendant to negate the mens rea of a crime. It is obviously not in the public interest for criminals to escape liability simply by asserting they were so drunk they did not know what they were doing. This is often seen as an aggravating factor rather than a mitigating factor, particularly where the defendant put himself in that position through voluntary intoxication. For this reason, the law draws a distinction between voluntary intoxication and involuntary intoxication. This video will focus on voluntary intoxication. Where the defendant is voluntarily intoxicated, the law draws a distinction between crimes of basic intent and crimes of specific intent. This distinction was drawn in DPP v. Beard and affirmed in DPP v. Majewski. The use of the terms basic intent and specific intent has caused confusion, not least because there has been conflicting dicta as to the meaning of these terms. In DPP v. Majewski, Lord Elwyn Jones suggested crimes requiring intention were specific intent crimes, whereas crimes for which recklessness would suffice were basic intent. Whereas Lord Edmund Davis and Lord Wilberforce in MPC v. Caldwell thought that the offence of arson, being reckless as to whether life was endangered, was a specific intent crime, despite the fact that it can be committed recklessly, because the state of mind went to an ulterior or purposive element of the offence, rather than to the basic element of causing damage by fire. No explanation of the terms is entirely satisfactory and do not accurately cover the offences which have been categorized as either basic intent crimes or specific intent crimes. This was most noticeable in R.V. Heard, 2007, where sexual assault was treated as a crime of basic intent, despite the fact that it can only be committed intentionally. Lord Justice Hughes stated, "No universally logical test for distinguishing between crimes in which voluntary intoxication can be advanced as a defense and those in which it cannot. There is a large element of policy. Categorization is achieved on an offense-by-offense basis." Crimes which have been categorized as being specific intent crimes include murder R.V. Lipman 1970 and Section 18 GBH and wounding R.V. Brown and Stratton 1997. Where a crime is categorized as being one of specific intent, the defendant is allowed to rely on their intoxication to demonstrate that they lack the mens rea of the offense. This is subject to the caveat that a drunken intent is nevertheless an intent as set out in R.V. Sheehan and Moore, 1975. Also the principle of Dutch courage. Dutch courage refers to where a person forms the intention to commit a crime and then drinks in order to enable them to carry out the crime. They cannot then claim the intoxication prevented them from forming the mens rea. In Attorney General for N.I. v. Gallagher 1963, the defendant wished to kill his wife. He went out and brought a bottle of whiskey and a knife. He drank the whiskey and then killed his wife with the knife and a hammer. He was not allowed the defense as he had formed the intention to kill prior to drinking. Crimes which have been categorized as crimes of basic intent include assault, battery, ABH and Section 20 GBH and wounding DPP v. Majewski 1977, sexual assault R.V. Heard 2007, rape R.V. Woods 1982, taking a conveyance without consent R.V. McPherson 1973, allowing a dangerous dog to be unmuzzled in public DPP v. Kellett 1994. Where a defendant's intoxication is voluntary and the crime is one of basic intent, the defendant is not permitted to rely on their intoxicated state to indicate that they lack the mens rea of the crime. Drunken mistakes are generally no defense to crimes of basic intent. In R.V. Fotheringham, 1989, the appellant had been out drinking. On his return home, he climbed into bed with the 14-year-old babysitter who was sleeping in the matrimonial bed. He started to have sexual intercourse with her in the mistaken belief that it was his wife. His conviction for rape was upheld. Rape is a crime of basic intent, and therefore his drunken mistake could not be relied on in his defense. In summary, the rules on intoxication differ depending on whether the defendant is voluntarily or involuntarily intoxicated. In cases involving voluntary intoxication, the availability of the defense depends on whether the crime is of specific or basic intent. For crimes of specific intent, the defendant's intoxication may be raised to demonstrate they lacked the mens rea. However, a drunken intent is still an intent. For crimes of basic intent, the defendant cannot assert that their intoxication caused them to lack the mens rea. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes.
Thanks for watching.